Within Chapter 2, we will look at legal entities and delve deeper into the judicial system within the United States. Once completed with this module, you should be able to identify and describe the various types of legal entities recognized in law, identify the basic components of our court system, describe the role of jurisdiction in the court system, describe the federal court system, describe state court systems, explain how a lawsuit progresses through the civil court system, explain how a criminal defendant proceeds through the criminal court system, and describe the mechanisms of alternative dispute resolution. To help develop your understanding of our court systems, we'll begin this chapter with a scenario in which you are called to participate in a deposition related to the care you provided to an EMS patient. If you have never participated in the civil legal process before, you may be wondering just what is a deposition. Maybe you have participated in mediation or arbitration in the past as a member of your union's collective bargaining team, but how is the process different in a lawsuit? Do you need to be represented by an attorney or your union at the deposition? In this particular scenario, neither you nor your agency is a party to the lawsuit. Does that mean you or your agency does not need to worry about losing the lawsuit? The answers to these and other questions should present themselves as we work through the material within this chapter. As a brief introduction to this chapter, our judicial system within the United States was built to ensure due process, predictability, efficiency, and justice. While some may argue how efficient or just the system actually is, these elements still remain guiding principles for our judiciary. For those unfamiliar with our system of courts, it is not uncommon to wonder how the judicial system determines which specific courts hear which cases, whether a plaintiff should file a lawsuit in a state versus federal court, what the process is for filing a lawsuit or prosecuting a criminal case, or even which rules are followed by the courts. While we are not going to delve too deeply into all of these topics, the information provided within this chapter should give you at least a cursory understanding of these and other factors related to our judicial system. Before we can dive right into evaluating our system of courts within the United States, it is of crucial importance to understand who the courts are designed to serve. Most people commonly understand that individuals are routinely processed through the court system, but there can be confusion as soon as we start discussing other legally recognized entities that are not actual human beings. Essentially, our laws within the United States recognize that there are times and instances where a group of individuals decide to associate with each other for a shared purpose. When this happens, those people may find it beneficial to create what is known as a legal entity that serves as the embodiment of their group. Some common examples of these legal entities include corporations, partnerships, municipalities, and associations. When formed in compliance with governing laws, these legal entities become an individual unto themselves with the same rights, privileges, responsibilities, and potential liabilities as private citizens. The law then commonly treats these legal entities as an autonomous person, meaning they can own property, enter into contracts, pay taxes, be a party to a lawsuit, and so on. Not only is this concept of legal entities important to the daily functioning of business, industry, and government, but it is an important concept for those of us in emergency services, as fire departments and EMS agencies are also considered to be legal entities. To evaluate these various legal entities, we'll begin by discussing subdivisions of government. As already mentioned briefly in Chapter 1 of the textbook, there are numerous levels of government within the United States, and these numerous entities, whether it be the federal government itself, your state or commonwealth, or a village, town, or city, are all considered to be legal entities. These subdivisions of government are governed by federal and state laws which may define a finite and specific scope for the entity, provide significant latitude in permissible business activities, or impose specific requirements that do not apply to other legal entities. An example may be a special taxing district, such as a school district or a fire protection district, that is limited in its scope and power by state law, as opposed to the state itself, which has pretty broad authority that is limited predominantly by the United States Constitution and the Constitution of the specific state. Aside from legal governmental entities, there are also business entities that are formed with the primary purpose of supporting business and industry. These types of legal entities are defined by state laws and can be diverse depending on the state. Common legal business entities include sole proprietorships, corporations, cooperatives, partnerships, limited liability companies, limited liability partnerships, and limited partnerships. There may also be other entities defined by the laws of a specific state. Companies such as Ford, Apple, Dell, Disney, and so on are all corporate business entities that are considered to be autonomous people under the law. That means these corporate entities have rights, duties, privileges, and potential liabilities under the law. In some scenarios, it may even be possible to levy criminal charges against a company or its officers. A somewhat recent example would be the Volkswagen case related to the intentional conspiracy to cheat United States emission tests. While it is obviously not possible to put a corporate entity in jail, it is possible for the levying of criminal fines against a legal entity. In this particular case, as reported by the United States Department of Justice Office of Public Affairs in January of 2017, Volkswagen pled guilty and paid a $2.8 billion criminal fine in addition to a $1.5 billion civil settlement for environmental, customs, and financial violations. The formation of legal business entities is very common and important to the functioning of our society, as these entities commonly provide some type of legal protection to those people involved in the formation and operation of the business entity. If a corporation goes bankrupt, for example, that does not mean the creditors can simply go after the company's officers, board of directors, or investors for payment. Again, the company itself is a separate private entity that exists outside of those who started or operate the company. It is important to keep in mind, however, that the level of protection available to those involved with the business entity can vary significantly depending on the type of legal business entity formed. Another distinction that can be made between legal entities are whether they are for-profit or non-profit entities. A for-profit business entity exists to make money for shareholders, partners, members, and other stakeholders. A non-profit entity, on the other hand, does not have shareholders and does not pay dividends on profits. Non-profit entities are not driven by a financial profit motive. Just because an entity is non-profit does not mean it is a charitable organization. Healthcare organizations, for example, are commonly non-charitable nonprofits. It is not unusual for such entities to work with a separate charitable nonprofit entity for fundraising, however. Essentially, charitable nonprofit organizations commonly focus on philanthropic goals and social well-being, which routinely involves the fields of education, religion, acts of charity, public interest, or other common good. Another type of legal entity important to fire and emergency services that must be explored is that of an association. Associations are legal entities that allow individuals to function as a single unit to accomplish a shared purpose. Examples include trade unions, environmental groups, neighborhood organizations, and professional associations. While associations are typically very easy to form and maintain, association members are not protected from liability for the actions of the association as they would be in a corporation. If one member of an association enters into a debt on behalf of the association, the other individual association members are just as liable for that debt as the person who initially assumed it on behalf of the association, even if that person did not have the permission of the others to enter into that debt. Unincorporated associations are also commonly limited in their ability to start legal actions, borrow money, enter into contracts, or hold property. Given these limitations, associations are still somewhat popular in specific cases because they are easy and inexpensive to form. They do not need to follow the restrictive rules imposed by the law on other business entities, and dissolution of an association is typically pretty easy. Given this introduction to legal entities, we can now focus on fire departments and EMS agencies specifically. The formation of fire departments and EMS agencies is commonly defined by state law, meaning the roles, rights, duties, privileges, and responsibilities can vary considerably. The federal government also creates fire departments based upon provisions that can be different from those in various state laws. Depending on how the fire department or EMS agency is created and who operates the department or agency, the fire department or EMS agency could be considered a state actor, a governmental entity, which means its actions are considered state governmental actions that will be judged with constitutional scrutiny if a dispute arises. This is especially important within the employment relationship, as governmental employers must comply with very specific constitutional due process protections that do not typically apply to private employers. Given this and other factors, it is vital for fire department and EMS agency leaders to be familiar with the nature of their department or service and the status of that department or service under applicable laws. The first clarification or differentiation to be made regarding the status of an emergency services agency is whether or not the entity is a governmental entity or a non-governmental private entity. A non-governmental or private fire department or EMS agency is one that was created under state laws as a business entity, most often a corporation. A governmental fire department or EMS agency is routinely established through some other state law regarding the governance of local municipalities or under a special law that addresses fire departments or EMS agencies specifically. As each state is different, the laws can vary considerably, and some states even allow for the creation of nonprofit corporations that function as fire departments or EMS agencies with governmental funding or authority. If created as a private entity, the fire department or EMS agency may still remain a vital component of essential services within its respective response territory or area. In other cases, such an entity may be supplemental to other governmental-based services. Again, there are numerous models for providing fire protection and EMS services across the United States. This textbook does not even begin to explore all of the potential variations that can exist. It is not unusual for private emergency service entities to contract with a municipality or other governmental entity to provide services, although it is also possible in some areas for them to function independently. These private entities may be either for-profit or nonprofit. Unless created under a specific state law that addresses it, private legal entities, even if providing emergency services, are not eligible for governmental immunity, nor do they fall under civil liability limits that commonly apply to governmental agencies and entities. Another important difference between private and governmental entities is the applicability of OSHA laws. All private entities are covered under federal OSHA. Governmental entities may or may not be covered by federal OSHA depending on the state. We will discuss OSHA in greater depth in another chapter. As mentioned briefly before, employees of private entities do not enjoy the same constitutional protections related to their jobs as employees with governmental entities. Some fire departments are not created as entities unto themselves, but they exist under or within another legal entity, such as a corporation or other business. Such fire departments are commonly referred to as industrial fire departments, as they are formed specifically for responding to emergencies that occur at the industry's site or sites. These fire departments are staffed by firefighters and EMS personnel whose only job is to function as firefighters or emergency responders. The ongoing training received by the fire department employees are typically governed by the types of hazards that exist at the locations for which they provide protective services. Many of these industrial fire departments are able to mitigate most of their emergencies without external assistance, although that can vary depending on the region, employer, industry, and circumstances. This is in contrast to what are commonly known as fire brigades. As opposed to being full-time firefighters, the members of a fire brigade perform other primary job duties unrelated to emergency services the majority of the time. If an emergency does occur, however, then these members leave their primary job function to perform firefighting or other duties, which may include first aid. Fire brigades commonly serve as a proverbial band-aid until a local fire department or EMS agency can respond to assist with the mitigation of the emergency, although the need for such external assistance may fluctuate based upon the size of the incident and the nature of the fire brigade. Many private businesses and employers, which could also include governmental employers, have developed their own internal emergency response teams to respond to emergencies that occur on their property. The training received by such teams can vary, but it is not unusual for them to receive some type of first aid and fire extinguisher training. As with fire brigades, the employees on these teams have other primary roles and duties they perform on a regular basis and assume an emergency response role only when needed. These teams must typically rely on other external emergency response entities to fully mitigate whatever emergency prompted the activation of the team. Obviously, there could be many different models of industrial fire departments, fire brigades, and emergency response teams employed across the country. The textbook gives just a quick overview of some of the most common traits associated with these different entities, although there is no one-size-fits-all definition for any of these entities. As always, it is incumbent upon fire service and EMS agency leaders to be familiar with the specific laws that govern these entities within their state. Some areas of the country are also serviced by subscription or fee-for-service emergency response entities. Fee-for-service fire departments and EMS agencies are one method of providing protective services without relying on tax-based funding. In such a model, EMS agencies bill their patients for services and fire departments bill impacted parties for emergency responses. In a purely fee-for-service system, no tax dollars are required to maintain services. It is also not unusual for some emergency response agencies, EMS in particular, to supplement tax-based funding with a fee-for-service model. Subscription agencies require customers to pay a periodic subscription fee to benefit from fire protection services provided by the agency. In such a system, if someone did not pay his or her subscription fee, the fire department may elect to not provide assistance to that individual given an emergency. There is also an emerging trend in some areas of the country where aeromedical transport services provide a subscription service that is almost akin to insurance to cover the cost of aeromedical transport services, or at least significantly reduce the fee-for-service cost if the subscriber would someday require the services of that agency. As governmental agencies continue to see budgets shrink and essential services are squeezed to do more with less, other creative financing models may continue to emerge and be employed in different proportions within various areas. The duty such emergency response agencies have to provide services to those in need can vary considerably depending on the laws in the state and how the emergency service entity was initially formed under those laws. Now that we have some understanding as to the types of legal entities served by the judicial system and how fire and EMS routinely fit into various legal entity categories, we can continue our exploration of the court systems within the United States. We stated in Chapter 1 that the United States is a country of laws. This means that when individuals or entities have disagreements or disputes, it is no longer acceptable to have a proverbial showdown at high noon. Rather, the aggrieved party has the ability to take the other party to court by filing a lawsuit. It is the job of the court system within the United States to adjudicate these disputes when they arise between legal entities, whether that be a person, a corporation, a fire department, the government, or another entity recognized under the law. Ultimately, if there is a legal problem or complication in some facet of our lives, whether it be criminal or civil in nature, the dispute may very well end up in a court. Therefore, an understanding of the court system is important for fire and EMS leaders who need to navigate this legal landscape. There are numerous different courts at different levels within the United States, and different jurisdictions demand their own types of court. The first type of jurisdiction that determines the court to hear a case is geographical jurisdiction. This type of jurisdiction is defined or limited by physical boundaries, such as city limits for municipal courts or the dividing lines between states, given state-based court systems. The second type of jurisdiction relates to the subject matter related to the case at hand. This type of jurisdiction is restricted by different areas of law. One such example is bankruptcy, which must be heard by a federal bankruptcy court. Another may be the difference between a federal court or a state court given an alleged criminal violation of either federal law or state law, respectively. For the time being, let's focus specifically on the federal court structure. While it is easy to think about our federal court system as a large and broadly encompassing system, the only court at the federal level established by name in the Constitution is the United States Supreme Court. All other inferior courts are created by Congress and must comply with any legal precedent established by the Supreme Court. The first or most basic level of courts within the federal system are the federal district courts. These are the trial courts for entry into the federal judicial system where lawsuits and complaints are initially filed. There are 94 district courts within the United States at the time this presentation was produced. In addition to these district courts, there are courts established at the federal level for handling bankruptcies, claims against the United States, and international trade. If there is a dispute as to the correct application of law by a trial court, the next stop in the federal court system is an appellate court. These circuit courts hear cases that originate in the trial courts with the purpose of ensuring the district courts within the circuit are interpreting the law correctly. There are 13 circuit courts within the federal system. While not as prevalent for those within the fire and EMS professions, the federal judicial system also recognizes the authority of some adjudicating bodies that are technically outside the judicial system or separate unto themselves, such as military courts, the Court of Veterans' Appeals, and administrative agencies with adjudicative authority. This map is produced by the Office of the United States Courts and denotes the geographic boundaries of the federal circuit courts. If you recall, we previously learned that there are 13 circuits, yet this map only displays 11. That is because the 12th Circuit is not actually numbered. It is the United States Court of Appeals for the District of Columbia Circuit. The 13th Circuit is also not numbered. It is the United States Court of Appeals for the Federal Circuit, which is unique in that its jurisdiction is defined solely by subject matter as opposed to geographical boundaries. This court has exclusive jurisdiction over appeals from certain courts and boards, such as the United States Court of International Trade, United States Court of Federal Claims, and the Civilian Board of Contract Appeals, to name a few. Federal courts are considered courts of limited jurisdiction as they may only hear specific types of cases. There are also restraints on what the courts can do. First, federal courts are not empowered to provide advisory opinions. This means an entity cannot ask a court preemptively how it would rule if presented with a specific factual scenario. For a federal court to issue an opinion, there must be an actual legal dispute. A case or controversy, as it is called, is required. As part of this case or controversy requirement, the plaintiff in the case must have standing to initiate the lawsuit. He, she, or the entity must have been legally harmed by the defendant in some way. While there are a few exceptions, a third party typically cannot bring or initiate a lawsuit on behalf of someone else. Whatever the case or controversy is, it must be one that can be remedied by the court, and the dispute must be ripe, which means the lawsuit presents a current, ongoing problem for the court to solve. If the harm has not occurred yet, then there is no case or controversy, and the case is not ripe. If the case has resolved itself, so to speak, then the issue is considered moot, and there is no case or controversy to be heard by the court. With these requirements in mind, federal courts may hear only two types of cases. The first is if the case involves a federal question, which typically means there is a dispute related to a federal law or regulation. The second is if there is a dispute between citizens of different states and the damages in dispute exceed $75,000. If neither of these two scenarios exist, then the case at hand probably falls squarely within the jurisdiction of a state court system. State court systems are designed to address legal disputes that arise within the geographical boundaries of the state. While the federal courts are considered to be courts of limited jurisdiction, the state courts have very broad subject matter jurisdiction and typically hear cases involving a wide assortment of legal topics such as divorces, child custody, criminal cases, probate, civil claims, and so on. These courts are governed by the state's constitution and the laws of that state. At the top of each state court system is a court of last resort, similar to the United States Supreme Court within the federal system. This court is the highest court in the state, and all other courts within the state are considered inferior to this court of last resort. While many states refer to their highest court as the state Supreme Court, that is not the case in every state. New York, for example, refers to its highest court as the Court of Appeals. Like the federal system, each state has a system of entry-level trial courts with some type of hierarchy to allow for at least one level of appeal. There may also be courts that are established by state law but exist outside of the state court system itself, such as municipal courts or traffic courts. State court systems typically also have special courts to address specific legal matters, such as guardianship cases, probate, or crimes involving minors. These various courts and systems can vary considerably from state to state, as does the method by which judges are selected within the state. Some positions are appointed, some are elected, and the terms vary as well. If you are interested in the court system within a specific state, it is recommended that you visit the state government's website to research details as to how the state's court system was designed and currently functions. Now that we have some familiarity with the structure of our federal and state court systems, we can delve deeper into the legal process itself. Specifically, we'll begin by looking at the stages of a civil lawsuit. As already mentioned, if a party or person is wronged by another, the solution is to seek redress through the courts. While the litigation process itself can be somewhat complicated, the steps are defined within rules of civil procedure either at the federal or state level. Generally speaking, there are four main stages to a civil lawsuit. The first step consists of pleadings and motions. The second is discovery. The third is the trial and judgment. And the last step is an appeal if warranted. As we proceed through these stages, you may want to refer to the flowchart provided on page 34 within the textbook. The first stage of a lawsuit encompasses pleadings and motions. The first step is for the plaintiff, the person or entity seeking redress from another party, to file a complaint with the court and serve a copy of that complaint to the defendant in the case, the person or entities being sued. Given the dispute in question, it is important for the plaintiff to ensure the complaint is filed with the correct court, whether that be a state court, a federal court, or a court with special jurisdiction over the particular subject matter of the case. Additionally, some systems require the defendant to be served with a summons and complaint before the complaint can be filed with the court. Given the idiosyncrasies of individual court systems and subject matter jurisdiction questions, it is in the plaintiff's best interest to work with an attorney to ensure all procedural steps are followed. Upon receipt of the complaint, the defendant has a specific time period in which to respond. In so doing, the defendant has several options. The defendant may file a counterclaim, essentially suing the plaintiff for damages suffered by the defendant. The defendant could file an impleader action to include third parties in the lawsuit. The simplest response to the complaint, if you will, is for the defendant to file a responsive pleading that addresses the issues raised in the complaint and provides the facts of the case as alleged or maintained by the defendant. Depending on the scenario and the jurisdiction, the defendant may have additional options as well. If the defendant fails to respond by the deadline, however, the court will award default judgment to the plaintiff. Assuming the defendant does file a responsive pleading, there are additional motions, legal requests, that may be made of the court. If the defendant does not believe the plaintiff has enough evidence to substantiate the claim, the defendant may ask the court to dismiss the lawsuit. If there is no dispute as to the material facts of the case, the defendant may ask the court for summary judgment, meaning the court decides the case based upon the applicable law. Depending on the content of the responsive pleading, the plaintiff may also make somewhat similar motions as well. If there are disputes between the parties as to the facts of the case, however, the lawsuit enters the next stage, discovery. The discovery stage is the one in which parties compile and share evidence pertinent to the case. The goal is for each side to have access to the same information. Rules of civil procedure routinely prohibit parties from concealing evidence from each other. The reason is that it is better for the legal system to ensure the parties have access to all the facts to ensure they are making a prudent decision as to whether or not a trial is warranted. If the plaintiff, for instance, has some overwhelming and persuasive evidence, the defendant may be more apt to try and settle the lawsuit before additional time and energy is expended by either party and the court. Having access to the evidence provides efficiencies in the system. As far as the discovery process is concerned, there are numerous mechanisms available for the parties to obtain evidence. One mechanism is a request for production that asks a party to produce documents or other tangible evidence related to the case. It is also possible to use a subpoena to request physical evidence from entities that are not a party to the lawsuit if such evidence has probative value for the case. Electronic records, including emails and other media, are often the subject of these requests. In complex cases, the amount of evidence available and produced can be immense, which increases the amount of time associated with the discovery process along with the associated cost. Requests for admissions can be used to ask a party to admit or deny certain facts associated with the lawsuit through the use of specific, carefully worded questions. Interrogatories are somewhat similar, although the questions are broader and typically open-ended. If there were witnesses to the event that gave rise to the lawsuit, it is somewhat routine for depositions to be used to obtain the sworn testimony of those witnesses. Depositions are also used routinely to obtain the testimony of expert witnesses. In the case of a medical malpractice lawsuit against an EMS agency, for example, the plaintiff may conduct a deposition of a physician considered to be an expert on the subject related to the lawsuit to allege some type of error on the part of the EMS agency to a reasonable degree of medical certainty, thus establishing the EMS agency's liability for the damages suffered by the plaintiff. The defendant EMS agency may, on the other hand, conduct their own depositions with different expert witness physicians who find no fault with the EMS agency's actions. Needless to say, especially where expert witnesses are concerned, such depositions can add significantly to the cost of litigation as expert witnesses are commonly reimbursed for their time and the hourly billing rates and other associated expenses of the attorneys, court reporter, videographer if there is one, and others must be factored in as well. All of these discovery mechanisms add time and cost to the legal process, which is why it is very common for the parties to settle without going to trial. If at the end of all discovery the respective parties cannot reach a settlement, the next stage of the lawsuit is to participate in a trial. Trials are expensive and they can be risky as well in that there is no guarantee the jury or court will find for any particular party, regardless of how strong a case the respective parties believe they have. Given the use of different motions available throughout the discovery phase, it can be possible for a case to be settled by the court without the parties themselves actually reaching a settlement. If such motions are unsuccessful and the parties still refuse to settle, then a trial is held to resolve the dispute. Once the court renders its final decision after the trial, the doctrine of res judicata prevents the plaintiff from filing another lawsuit against the same defendant for the same matter. The final decision by the court closes the matter for good, unless there is an appeal, which will be discussed in a little bit as the fourth potential stage of a lawsuit. Before we can talk about appeals, however, it is important to understand the difference between the roles of a jury versus that of a judge at trial. It is the responsibility of the jury to be the trier of fact. As the evidence is presented, the jury must use that evidence to decide what actually happened in the case and who is responsible as a result. The judge is responsible for ensuring the rule of law is followed during the trial. The judge also instructs the jury as to how the law is applied to the case at hand. It is not the judge's role to decide the facts of the case, however. That, again, is the jury's responsibility. With that being said, there are two different kinds of trials that can occur in a civil case. The first is a jury trial in which a jury of citizens is responsible for differentiating fact from fiction. In some cases, however, the case is heard in what is known as a bench trial, in which the judge must not only apply the law to the facts of the case, but must also take the place of the jury to determine just what those facts are. Again, the different roles of a judge and jury at trial are important to understand when evaluating whether or not a case can be appealed. Another important facet of civil procedure to understand is the burden of proof in a civil case. Essentially, the burden of proof standard establishes who has to prove what and to what degree in order to be successful in the civil case. Within a civil case, the burden of proof is typically considered to be by preponderance of the evidence. This means that the weight of evidence just tips the proverbial scales to one side or the other. The probability of the allegation being true is greater than 50%. It is more likely than not. That is the extent of the application of the preponderance of the evidence standard. This burden of proof also applies initially to the plaintiff in the case. It is the responsibility of the plaintiff to meet this burden of proof. If the defendant does not feel the plaintiff has met this burden and the court agrees, the defendant need not even present evidence to be successful. If the plaintiff makes a somewhat persuasive argument, however, the defendant may feel compelled to shoulder the burden of then dispelling the plaintiff's allegation and evidence by the same preponderance of the evidence standard. In this fashion, the burden may actually move back and forth between the parties as each one tries to sell their evidence while undermining the value and credibility of the other party's evidence. Keep in mind as well that this burden of proof is not established by volume. Stated another way, the quantity of evidence provided is not as important as the quality of evidence provided. The plaintiff may have a dozen people testify in its behalf, but if the defendant has just one witness who the jury believes is more credible, that is enough to tip the scales in favor of the defendant. As far as the burden of proof is concerned, while the plaintiff typically shoulders the burden of proof, there are cases where the burden of proof may actually fall upon the defendant. One such case is if the defendant is trying to make an affirmative defense. An example may be a trespassing case where the defendant tries to use the defense of necessity to alleviate liability. The burden of proof for such an affirmative defense falls on the defendant. As far as fire and EMS are concerned, the application of a legal presumption is also important in evaluating the burden of proof. Such a case may be an EMS crew sued for complying with a legal do not resuscitate order where the state law protects EMTs functioning in good faith and also creates a presumption of that good faith. It could also apply in a workers' compensation case for a firefighter with cancer. Many state laws create a presumption that a firefighter with certain types of cancer, after working a given amount of time in the profession, actually contracted the cancer as a part of his or her employment duties, making the ailment compensable under workers' compensation laws. Overcoming such presumptions can be difficult as the burden of proof in such cases is higher than a simple preponderance of the evidence. In discussing burden of proof along with the other phases of a lawsuit, we mention the word evidence frequently. Court cases are determined not based upon rainbows, wishes, and happy thoughts, but based upon evidence. Evidence is essentially anything that helps support a proposition or claim. It is something real and tangible that is established or can be proven. Documentation, such as a fire incident report or an EMS patient care report, is evidence. Physical items like pictures of skid marks taken at the scene of a motor vehicle collision are evidence. Even witness testimony is evidence, as such testimony lends itself to helping the finder of fact in the case, the jury, determine what did in fact happen. As far as testimony is concerned, there are two types: lay witness testimony and expert witness testimony. Expert witnesses are vetted through the court to provide opinion to a reasonable degree of certainty in the witness's particular field. A fire investigator, for example, is commonly qualified as an expert witness to give his or her opinion as to the cause and origin of the fire. Lay witnesses, on the other hand, can testify as to what they saw, heard, or otherwise observed through their senses: sight, hearing, smell, touch, etc. Unless an opinion is one related to general lay knowledge or experience, like approximating how fast the witness thought the ambulance was driving before the accident, lay witnesses are not allowed to testify as to their opinions. In discussing witness testimony, it is also important to understand the concept of hearsay. Hearsay is defined as an out-of-court statement made by someone other than the witness, presented to prove the truth of the matter asserted. Stated another way, hearsay is when a witness does not have personal knowledge of a fact and must rely on information provided or statements made by someone else. That type of evidence is generally not allowed at trial. If a party wants to know what someone observed, they must typically ask that person directly at the trial. With that being said, there are exceptions to the hearsay rule, such as a dying declaration, recorded recollection, statements made for the purpose of medical diagnosis or treatment, and a few others. This is one of the reasons why proper documentation is so important for fire department and EMS agency personnel. Without proper documentation, some important evidence in a subsequent court case may be excluded as hearsay. With this background in mind as to the difference in roles between a judge and jury, along with the burden of proof, types of evidence available, and the inadmissibility of hearsay, we now have a frame of reference in which to discuss the fourth stage of a lawsuit, the appeal. If one party believes there was a mistake of law made within the process, that party may seek to appeal the trial court's decision based upon that alleged incorrect application of law. Notice I used the phrase mistake of law a couple times in that sentence. That is because the losing party cannot appeal simply because it did not agree with the jury's decision. The jury is the finder of fact, and if the jury decides the facts one way or the other, that decision is final and cannot be appealed. Again, the appeal must be based upon an alleged mistake of law that was made by the judge in the case. Interestingly enough, it is often necessary for the party alleging the incorrect application of law to actually object to the court at the time the alleged mistake was made to preserve the right to appeal that decision later. If the party fails to object when the mistake was made and then tries to appeal the case based upon that mistake, the appeals court may dismiss the appeal because the appealing party failed to make a timely objection to the legal error. This is another reason why competent legal services from an attorney is so important if you ever find yourself a party to a lawsuit. Depending on the issue involved in the appeal, there could potentially be multiple levels of appeals available. Say, for instance, that the trial court made the alleged error of law, which was appealed to the court system's appeals court, which subsequently supported the decision of the trial court. If the issue is important enough, the state Supreme Court, or court of last resort, may decide to hear the case. In extreme circumstances, the United States Supreme Court may even be an option for a final appeal. Regardless of where the appeals process stops, there will be a point at which all options are exhausted and the final judgment stands, concluding the civil litigation process. The other type of court case in which fire departments and EMS agencies may be involved are those related to the criminal court system. The criminal court system has a very different set of rules and procedures for moving through the system. The flowchart displayed here, which is also included on page 39 of the textbook, outlines a common process followed by many criminal court systems. While we will discuss this particular process, keep in mind that there are other variations that may be followed in specific jurisdictions. As always, it is important for you to be familiar with the laws and criminal process within your state and particular jurisdiction. Despite local fluctuations in specifics, the general spirit of the process we are about to discuss is common across most criminal court systems. The process begins with someone being arrested, booked, and either detained or released based upon bail practices in the jurisdiction and the specific type of crime involved. There is a process of filing formal charges or information, followed by the defendant's arraignment. If a plea bargain is not reached at any point throughout these initial steps, the case goes to trial. If the criminal defendant is found guilty, then there is a sentencing process, which may be followed by an appeal. Let's look at these steps individually. To begin, an individual enters the criminal justice system by being arrested by a law enforcement agency. Once at the police department or other processing center if arrested by an agency other than a local police department, the accused is booked into the system, which includes mugshots, fingerprinting, and maybe even DNA collection in some jurisdictions. Depending on the nature of the crime, the individual may be released or will remain in jail until a bail hearing to determine how much money must be paid in bond to secure his or her release while awaiting trial. At some point after the individual's arrest and booking, the prosecutor with jurisdiction over the case must decide whether or not the people want to pursue the case. The prosecutor may decide to not pursue some cases based on a lack of severity, tenuous evidence, or other considerations. If the case is one the prosecutor wants to pursue, formal charges are then filed with the court. Depending on the jurisdiction, these charges may be filed through a criminal complaint or through a document called the information, in which alleged criminal acts of the defendant are detailed. In some cases and jurisdictions, the prosecutor may seek to utilize a grand jury to first determine if there is enough evidence to pursue a case before deciding whether or not to file charges. Many people are surprised to hear that grand juries actually work for the prosecutor in an investigatory role, and the defendant is commonly not involved or represented in the grand jury process. Again, the grand jury helps the prosecutor decide whether he or she will pursue the case based upon the evidence available. As this is just one more step in the prosecutor's internal decision-making process, there is no due process issue with the defendant not having representation in this process. If the grand jury does indeed believe criminal charges are warranted in the case, it will issue an indictment. In the absence of a grand jury process, some jurisdictions, based upon the nature of the crime, may require a preliminary hearing in front of a criminal law judge to determine if there is enough evidence, based upon probable cause, to force the defendant to stand trial. Unlike a grand jury process, the criminal defendant is a participant in the preliminary hearing process and may even present evidence on his or her behalf. Assuming charges are eventually filed against the defendant, the next step is the arraignment, where the defendant enters his or her plea of guilty, not guilty, or no contest with the court. If the defendant enters a plea of guilty or no contest, the process skips down to the sentencing stage. Such pleas are typically the result of a plea bargain between the prosecutor and the defendant, where the prosecutor offers a lower sentence in exchange for a guilty or no contest plea. Given the volume of cases within the criminal justice system, plea bargains are common and powerful for alleviating congestion within the system. The benefit of a plea bargain to the criminal defendant is the knowledge of a certain outcome. As a matter of fact, there is some research that suggests even the occasional innocent person takes a plea bargain to bring the process to a prescribed conclusion and not risk the uncertainty that arises through a criminal trial. For the truly guilty person, the plea also gives the criminal defendant an opportunity to control his or her proverbial fate and potentially receive a much lighter sentence than may be received if the case goes to trial. On the flip side, the people benefit through the efficiency of a guaranteed conviction. It may be better to have the criminal defendant in jail for a year based upon a plea than maybe not at all if the trial court eventually finds him or her not guilty. While the prosecutor has tremendous latitude in developing plea agreements with criminal defendants, such agreements must ultimately be approved by the court. If the criminal defendant does not take a plea bargain, assuming one was even attempted or offered, and enters an arraignment plea of not guilty, the criminal defendant must then await his or her day in court. During this period of time, discovery can occur similar to a civil case. During this time, pretrial motions may also be introduced, and if additional evidence is discovered by either side, that may impact the case as well. Say, for instance, that a witness presents cell phone video that shows the criminal defendant is innocent of the charges. The prosecutor would then drop the case. On the flip side, maybe the cell phone video is rather damning for the criminal defendant. That may spur him or her to consider a plea bargain if the prosecutor is willing to discuss one, that is. After all of that, if there are no motions that result in the charges being dismissed, the prosecutor does not drop the charges, and no plea bargain is reached, the case will go to trial, which is the highest profile part of a criminal case. Depending on the particular case, there may actually be a tremendous amount of notoriety surrounding the criminal trial. With that being said, most criminal cases do not reach this phase, as more than 90% of all criminal convictions result from negotiated plea bargains. As with a civil case, there is a burden of proof that must be met by the prosecution in the case. The Constitution assures that every criminal defendant is innocent until proven guilty. Unlike a civil case, a mere tipping of the proverbial scales of justice, a preponderance of the evidence, is not enough to establish criminal culpability. Rather, it is the burden of the prosecution to prove every element of the crime beyond a reasonable doubt to secure a conviction. Because this burden falls upon the prosecution, there are many cases in which the defendant does not even take the stand on his or her own behalf. If the defense believes the prosecution failed to meet that burden, there is nothing the defendant needs to do. Believe it or not, technically speaking, the burden to prove innocence does not actually exist in light of this burden of proof, even if the prosecution is able to meet the beyond the reasonable doubt threshold. What I mean by saying that is this: if the prosecution is successful in meeting its burden, the burden of proof then shifts to the defendant to not prove innocence, but to simply inject a reasonable doubt in the minds of the jury. Notice the threshold is not the absence of all doubt in the minds of the jury. The burden is beyond a reasonable doubt. Similar to a civil case, if the defendant is trying to exert an affirmative defense, then the defendant has the burden of proof associated with substantiating that affirmative defense. Beyond that, however, the burden of proof in a criminal case falls squarely on the shoulders of the prosecution to prove all elements of the crime beyond a reasonable doubt. This is a significantly higher threshold than the preponderance of evidence threshold used in civil cases. Once all evidence is presented, assuming there were no motions during the trial that would result in a dismissal, the criminal defendant did not change his or her plea, or a plea bargain was offered and accepted, the court will reach a final verdict. If the defendant is acquitted, meaning he or she is found innocent or not guilty, the Fifth Amendment prohibition against double jeopardy means the defendant may not be prosecuted for the same crime at a later date, even if additional evidence is made available later that supports a guilty verdict. On the other hand, if the defendant is found guilty of some or all of the charges, the next step is for the criminal defendant to be sentenced. This sentencing is commonly influenced by laws that delineate the type of punishment associated with various crimes. A Class A felony may provide for life in prison or even the death penalty, as opposed to a lesser felony where the time frame for incarceration could be relatively minimal. Some laws carry minimum sentencing guidelines, meaning the court must sentence in accordance with prescribed minimums. Without such guidelines, judges commonly have latitude in sentencing decisions. If the sentencing results in the death penalty in the federal system or in states with the death penalty, there is typically another process or mechanism in place to ensure the defendant's due process rights are indeed respected. Ultimately, once the sentencing is completed, the defendant has the right to appeal the decision if he or she believes there was an error made in the application of the law. Similar to civil cases, the defendant cannot appeal the finding of fact. He or she must base an appeal upon an alleged error of law by the court. Additionally, the error is only appealable if the defendant objected to the error at the time when it occurred during the trial. As the criminal justice system deals directly with constitutional guarantees such as due process, equal treatment under the law, and other fundamental rights, the right to an appeal exists in all cases and, given extraordinary circumstances, the United States Supreme Court may even decide to hear the case. Given this overview of both the civil and criminal court systems and their associated processes, there is one last topic that we need to explore as it relates to civil litigation. There is an emerging trend in the United States to utilize what is known as alternative dispute resolution to control litigation costs and speed up the civil litigation process while also reducing the burdens on the civil court system. The alternative dispute resolution mechanisms of mediation and arbitration are commonly employed within contracts between parties to resolve disputes outside of a formal lawsuit and civil proceeding. Mediation is a process by which a mediator works as an intermediary between the parties to work out a settlement or agreement. Arbitration is a little different in that the arbitrator typically has the ability to decide a dispute and enforce judgment. Depending on the nature of the arbitration process, there may be a single arbitrator or, more commonly, a panel of 3 arbitrators who make the final determination on the case. While I just said the arbitrator typically has the ability to decide a dispute and enforce judgment, there are different types of arbitration, including mandatory or voluntary, along with binding or non-binding. Within the realm of the fire and EMS professions, mediation and arbitration are commonly factors in collective bargaining contract disputes. As a result, we will explore these topics in greater depth within the chapters on contracts, Chapter 5, and employer-employee relationships, Chapter 10. To summarize this chapter, remember that the judicial system in the United States is structured to ensure due process, predictability, efficiency, and justice. We also discussed legal entities, which are formed when groups of people wish to associate for a shared purpose. Legal entities can include businesses, associations, levels of government, fire departments, EMS agencies, and so on. If disputes arise between legal entities, it is the responsibility of the courts to adjudicate those disputes. There are different jurisdictions that necessitate different types of courts, whether that is based upon the level of government involved, a specific geographical region, or the subject matter of the dispute. The only court actually established by name in the Constitution is the United States Supreme Court. Additional federal courts are established below the Supreme Court by Congress. There are also state court systems designed to address legal disputes that arise within the borders of those various states. We also explored the different processes between civil and criminal courts. There are 4 common stages of a civil lawsuit: pleadings and motions, discovery, trial and judgment, and an appeal. The stages of a criminal court process include arrest, booking, bail, formal filing of charges, information, arraignment, trial, sentencing, and appeal. If you found our exploration of the civil and criminal court systems interesting, there's plenty more of that to come. In the next chapter, we will delve deeper into crimes that impact the fire service and EMS professions, along with principles of criminal procedure.